Hello, friend. Today we're going to talk about the making of an application for an emergency protection order, and we're going to look at what the court is going to look at when making such an application without giving notice to parties, or when an ex parte application is made. And the relevant case law that we're going to consider is the case of X Council versus B, reported in 2005, 1 FLR from page 341. In that case, Mr. Justice Mumby set out the domestic and European Court of Human Rights case law relating to emergency protection orders, and he made 14 points that need to be considered whenever an application is being considered. An EPO is essentially the removing of a child from his parents. It is a draconian and extremely harsh measure requiring exceptional justification and extraordinary compelling reasons. Such an order should not be made unless the family court is satisfied that it is both necessary and proportionate, and that no other less radical form of order will achieve the essential end of promoting the welfare of the child. Separation is only to be contemplated if immediate separation is essential to secure the child's safety. Imminent danger must be actually established. Number one, both the local authority which seeks and the family court which makes an emergency protection order assume a heavy burden of responsibility. It is important that both the local authority and the family court approach every application for an emergency protection order with an anxious awareness of the extreme gravity, the relief being sought, and a scrupulous regard for the European Convention right of both the child and the parents. Number two, any order must provide for the least interventionist solution consistent with the preservation of the child's immediate safety. If the real purpose of the local authority's application is to enable it to have the child assessed, then consideration should be given to whether that objective cannot be equally effective and more proportionately be achieved by an application for or by the making of a child assessment order under Section 43 of the Children Act 1989. No emergency protection order should be made for any longer than is absolutely necessary to protect the child. Where the emergency protection order is made on an ex parte, in other words, without notice, application, very careful consideration should be given to the need to ensure that the initial order is made for the shortest possible period, commensurate with the preservation of the child's immediate safety. The evidence in support of the application for an emergency protection order must be full, detailed, and compelling. Unparticularized generalities will not suffice. The sources of hearsay evidence must be identified. Expressions of opinion must be supported by detailed evidence and properly articulated reasoning. Save in wholly exceptional cases, parents must be given adequate prior notice of the date, time, and place of any application by a local authority for an emergency protection order. There must also be given proper notice of the evidence that the local authority is relying upon. Where the application for an emergency protection order is made ex parte, the local authority must make out a compelling case for applying without first giving the parents notice. An ex parte application will normally be appropriate only if the case is genuinely one of emergency or other great urgency. And even then, it should normally be possible to give some kind of, albeit informal, notice to the parents, or if there are compelling reasons to believe that the child's welfare will be compromised. Where the application for an emergency protection order application is made ex parte, the local authority must make out a compelling case for applying without first giving the parents notice. An ex parte or without notice application will normally be appropriate only if the case is genuinely one of emergency or other great urgency. And even then, it should normally be possible to give some kind of, albeit informal, notice to the parents, or if there are compelling reasons to believe that the child's welfare will be compromised if the parents are alerted in advance to what is going on. The evidential burden on the local authority is even heavier if the application is made ex parte. Those who seek relief ex parte are under a duty to make the fullest and most candid and frank disclosure of all the relevant circumstances known to them. This duty is not confined to the material facts. It extends to all relevant facts, whether of fact or law. Section 45, subsection 7, subsection B of the Children Act 1989 permits the court to hear oral evidence. But it is important that those who are not present should nonetheless be able to know what oral evidence and other material have been put before the court. The court must keep a note of the substance of the oral evidence and must record in writing not merely its reason but also any findings of fact. The local authority should immediately, on request, inform the parents of exactly what had gone on in their absence. Parents against whom an emergency protection order is made ex parte are entitled to be given, if they ask, proper information as to what happened at the hearing and to be told, if they ask, 1. Exactly what documents, bundles, or other evidential material were lodged with the court either before or during the course of the hearing, and 2. What legal authorities were cited to the court. The local authority's legal representatives should respond forthwith to any reasonable requests from the parents or their legal representatives, either for copies of the materials read by the court or for information about what took place at the hearing. It will therefore be prudent for those acting for the local authority in such a case to keep a proper note of the proceedings, lest they otherwise find themselves embarrassed by a proper request for information which they are unable to provide. Section 44, subsection 5, subsection B of the Children Act 1989 provides that the local authority may exercise its parental responsibility only in such manner as is reasonably required to safeguard or promote the welfare of the child. Section 44, subsection 5, subsection A provides that the local authority shall exercise its power of removal under Section 44, subsection 4, subsection B, subsection 1, only in order to safeguard the welfare of the child. The local authority must apply its mind very carefully to whether removal is essential in order to secure the child's immediate safety. The mere fact that the local authority has obtained an emergency protection order is not in itself enough. The family court decides whether to make an emergency protection order, but the local authority decides whether to remove. The local authority, even after it has obtained an emergency protection order, is under an obligation to consider less drastic alternatives to emergency removal. Section 44, subsection 5 requires a process within the local authority whereby there is a further consideration of the action to be taken after the emergency protection order has been obtained. Though no procedure is specified, it will obviously be prudent for the local authority to have in place procedures to ensure both that the required decision-making actually takes place and that it is appropriately documented. Consideration should be given to drawing up an emergency protection order removal plan and getting it agreed by the senior managers. Consistently with the local authority's positive obligation under Article 8 to take appropriate action to reunite parent and child, Section 44, subsection 10A and Section 44, subsection 11A impose on the local authority a mandatory obligation to return a child who it has removed under Section 44, subsection 4, subsection B1 to the parent from whom the child has been removed if it appears to the local authority that it is safe to do so. Thus, this imposes on the local authority a continuing duty to keep the case under review day by day so as to ensure that the parent and child are separated for no longer than it is necessary to secure the child's safety. In this, as in other respects, the local authority is under a duty to exercise exceptional diligence. Section 44, subsection 13 of the Children Act 1989 requires the local authority, subject only to any direction given by the family court under Section 44, subsection 6, to allow a child who is subject to an emergency protection order reasonable contact with his parent or her parents. Arrangements for contact must be driven by the needs of the child and family. We shall now turn to another relevant case. That's a case of Re-X 2006, reported in EWHC from page 510 FAM. McFarlane J. delivered judgment in a case where the local authority had removed a child under an emergency protection order and then successive interim care orders, only to return the child to her family after 14 months when the care proceedings concluded, with the threshold criteria not having been established. The judge quoted the Child Act Guidance and Regulation Volume 1 from page 51, and I quote, "The purpose of the new law, as its name suggests, is to enable the child in a genuine emergency to be removed from where he is or be kept where he is, if and only if this is what is necessary to provide immediate short-term protection," and said the word genuine emergency and only what is necessary to provide immediate short-term protection cannot, in my view, be stressed enough. McFarlane J. then went on to set out additional guidance. Number 1. The 14 key points made by Mumby J. in Ex-Counsel versus B should be copied and made available to the justices hearing an emergency protection order on each and every occasion such an application is made. B. It is the duty of the applicant for an emergency protection order to ensure that the Ex-Counsel versus B guidance is brought to the court's attention or the bench. C. Mere lack of information or a need for assessment can never of themselves establish the existence of a genuine emergency sufficient to justify an emergency protection order. The proper course in such a case is to consider application for a child assessment order or issuing a Section 31 proceedings and seeking the court's direction under Section 38(6) for assessment. D. Evidence given to the justices should come from the best available source. In most cases, this will be from the social worker with direct knowledge of the case. E. Where there has been a case conference with respect to the child, the most recent case conference minutes should be provided to the court. F. Where the application is made without notice, if possible, the applicant should be represented by a lawyer, whose duties will include ensuring that the court understands the legal criteria required both for an EPO, emergency protection order, and for an application without notice or ex parte. G. The applicant must ensure that a full note as possible of the hearing is prepared and given to the child's parents at the earliest possible opportunity. H. Unless it is impossible to do so, every without notice hearing or ex parte hearing should either be tape recorded or be recorded in writing by a full note being taken by a dedicated note taker who has no other role, such as a clerk, to play in the hearing. I. When the matter is before the court at the first on-notice hearing, the court shall ensure that the parents have received a copy of the clerk's note of the EPO hearing, together with a copy of any material submitted to the court and a copy of the justice's reasons. J. Cases of emotional abuse will rarely, if ever, warrant an emergency protection order, let alone an application without notice. K. Cases of sexual abuse where the allegations are inchoate and non-specific and where there is no evidence of immediate risk of harm to the child will rarely warrant an emergency protection order. Cases of fabricated or induced illness where there is no medical evidence of immediate risk of direct physical harm to the child, will rarely warrant an emergency protection order. M. Justices faced with an emergency protection order application in a case of emotional abuse, non-specific allegation of sexual abuse and or fabricated or induced illness should actively consider refusing the emergency protection order application on the basis that the local authority should then issue an application for an interim care order. Once an application for an interim care order has been issued in such a case, it is likely that the justices will consider that it should immediately be transferred up for determination by a county court or the High Court or the family court with equivalent of a circuit judge or a district judge or even a High Court judge. N. The requirement that the justices give detailed findings and reasons applies as much to an emergency protection order application as it does to any other application. In a case of urgency, the decision may be announced and the order made with the detailed reasons prepared thereafter. O. Where an application is made ex parte or otherwise known as without notice application, there is a need for the court to determine whether or not the hearing should proceed on a without notice basis, and to give reasons for that decision independently of any subsequent decision upon the substantive emergency protection order application. We're also going to consider one other relevant case, and that is the case of R open bracket G versus Nottingham City Council, reported in 2008 in EWHC from page 152, open brackets, admin, close brackets. In this case, Mr. Justice Mumby made clear that the separation of a newborn baby from his mother by placing the baby in a different room in the hospital was unlawful, where in the absence of parental consent there was no judicial sanction, i.e. there was no emergency protection order or an interim care order, and there was no suggestion that either A, the mother posed a risk of exposing him to immediate physical attack or physical harm, or B, there was a medical justification for his separation stroke intervention. M, in this case, the mother, was only 18 and had a history of alcohol and drug abuse and had self-harmed. She had been in the care of Northampton. Prior to mother giving birth, an interagency child protection conference had been held and a birth plan was prepared for medical staff at the hospital where the mother was to give birth. The conference recommended that the local authority should apply for an interim care order following the child's birth and organize a foster placement. The Child Protection Conference also recommended that the child should not be removed from the ward by the mother, and an emergency protection order should instead be sought if the ICO order was not in place, that the child should remain in the hospital until taken into foster care. The birth plan given to the hospital stated that the child was to be removed from the mother's care at birth, but made no reference to obtaining either an emergency protection order or an interim care order. Approximately 2 hours after the mother gave birth, the child was removed from the mother and placed in a different room in the hospital. In argument in the proceedings and on behalf of the mother, it was submitted that separating her from her child was unlawful and it had been done without legal authority. Mr. Justice Mumby held that the local authority had no power to remove children from their parents unless they had first obtained judicial sanction for what they were proposing to do. Only a court could make an interim care order or an emergency protection order. Only if a court had authorized that step, whether by making an interim care order or an emergency protection order, could a local authority or social worker remove a child from a parent. That also applied to a hospital and its medical staff. However, this was subject to two qualifications. The first is this: a social worker or a nurse was entitled to intervene if it was necessary to protect a baby from immediate violence at the hand of a parent. In this case, there was no suggestion that the mother posed any risks to the child of immediate physical attack or physical harm. Number two, further, doctors, midwives, and nurses were entitled to separate a child from its mother if medical necessity dictated, even if she objected. However, in this case, there was no objection of any medical justification for the intervention, let alone any medical emergency. The child was removed simply because of the birth plan. We're now going to talk about steps to be taken when preparing for an application for emergency protection order. When a decision has been made by the local authority to make an application for an emergency protection order, the social worker should prepare a written statement of evidence to support the application for an emergency protection order. The evidence must be provided from the best available source, and this will usually be from the social worker who has thorough knowledge of the factual background of the issues affecting the child. As part of the consideration for making an application of emergency protection order, several things must be borne in mind when that application is being made. The first is that, is the local authority, as part of the emergency protection order, going to seek what we call an exclusion requirement? In other words, to exclude a person from the home in which the child lives. Secondly, consideration must be given to whether there is need for authorization or prohibition of medical or psychiatric or an assessment of the child. Consideration must also be given to contact with parents and others who are connected to the child. Consideration must be given to authorization to enter and search for the named child. Consideration must be given as to whether there is need for a registered medical practitioner to assist with the effecting the order. Consideration must also be given to whether a warrant which would authorize police to assist in entering and searching the premise using reasonable force is necessary. Consideration must also be given to whether the matter needs to proceed in a normal way, giving notice to parent, or whether the application needs to proceed on an ex parte basis or without notice to parents. A further consideration must also be given to whether the application is made during work hours or whether the application is going to be made out of hours. Now, these factors which I've raised are key, and the detail and how they affect the case will vary from application to application. We're now going to talk about what happened at an emergency protection order hearing. At the hearing, the court will have had opportunity to read the papers, and usually or sometimes what will happen is all the parties will be in attendance. However, the court will keep parties waiting while the court properly digests all the information that has been submitted. Subsequent to that, the parties will be called in. The local authority will then present their case and give the reason why they're seeking the emergency protection order and cite the case laws that are relevant. If the parents are in attendance and are legally represented, the court will hear from the legal representatives, and where the guardian is also in attendance, will hear from the guardian's legal representative and then make a decision. However, there are instances where the parents are not present for whatever reason. There is a greater degree of expectation from the local authority to be candid and provide all information necessary to enable the court make a decision. And it's not a given that the court will automatically make an emergency protection order, because the court will ask the following questions as part of its inquiries. What inquiries have been made to connected persons or the wider family? The court will ask what the position of the parents are in respect of the application. The court will want to know whether an exclusion order will suffice. The court will also want to know whether the local authority has asked for the parent to consent to a Section 20 placement pending further inquiries of what has happened to the child. And so there are a number of other issues, evidential issues, which the court will go into, given the various guidance the court have provided over the years, and then the court will make a decision. Once the court has made a decision, an order will be drawn up and provided to the parties immediately after the hearing, usually through their legal representatives. I hope you have found this helpful in your understanding of an emergency protection order application and the procedure for making such an application. Thank you.